Hi and welcome back. The next couple of clips will be dedicated to the topic of treaties, which is arguably the most important source of international law. Jan Klabbers also has an entire chapter in his textbook on the topic of treaties, so I will also introduce the various elements, starting with this first video, kind of the general outlines of treaty law, and also on the topic of how treaties are made. The second clip, which actually is from my human rights course, will talk about reservations under international human rights law, but also general international law. And in the third video, I will talk about the application and interpretation of treaties. Now, treaties are considered the most important source because they are the workhorses of international law, as Klabbers says. This means that the vast majority of international law, the vast majority of international legal obligations are actually made and formalized through treaties. And this should not surprise us because imagine you're a state or a group of states, you're encountering a specific issue and you need to tackle it together. How can you do it? Well, customary international law, as we saw last week, will not be helpful because, in fact, it only, in most cases, gradually develops. And even then, we don't know when actually the threshold is met to actually create international legal obligations. Well, a treaty can be negotiated, the obligations can be put down on paper, they can be made explicit, and then states can move on to immediately make it effective, to sign and ratify. So how do we define a treaty? We will find a straightforward answer to this question in the Vienna Convention on the Law of Treaties, in short, often abbreviated as VCLT, which we have already encountered in previous clips. And here in Article 2.1a, the VCLT defines it as an international agreement concluded between states in written form and governed by international law, whether embodied in a single instrument or in two or more related instruments. You can find all the essential elements here. Of course, there's state consent, the foundational principle of international lawmaking. These obligations are put down in written form, and also they're governed by international law, as we will see in a minute, through the adoption of treaties, but also in the application and interpretation. That's for the third clip. But apart from this, treaties can actually take different shapes or forms. For instance, a treaty can be bilateral, so applicable only between two specific states, or multilateral, so three or more states that are party to it. It can be global in nature, think for example of the UN Charter, but it can also be more regional. Think for example of the Council of Europe and the European Convention on Human Rights, which is applicable only in Europe. Treaties can also be constituent, meaning that they establish an international organization and delegate certain powers to it. We'll talk about delegation in the third part of this course. Think, for example, of the European Union, which actually through the Treaty of Rome and by now through a much more complex treaty system under international law creates the European Union with all its institutions, the Commission, the Council, the Court, which are being delegated powers by states that they can then exercise. Another count on which various treaties will differ is the title, their name. And here next to me you will see a number of titles that could all potentially indicate that we have a treaty in front of us. So whether that's a covenant, an agreement, an act, all of these are potentially treaties that are binding between states. Now, in order to know for sure whether something is a treaty, so legally binding under international law, you will have to look into the document itself and see what states intended, how they framed, worded the various paragraphs, and whether there is really an intent to create legally binding obligations. Now, certain titles, most notably covenant or convention, usually indicate a legally binding treaty, but it doesn't have to be the case, and as already said, all the other names are also potentially treaties. The one exception to this rule is the MOU, which stands for Memorandum of Understanding, which is a term that states deliberately use when they come up with a document to indicate that there are no legally binding obligations in there, but rather that this is a document that shows political commitment. Now, a few words on the Law of Treaties and specifically on treaty making. And for this, we look at the Vienna Convention on the Law of Treaties, which I would strongly recommend to find on the internet and have a look at by yourself, because it does regulate all these technical matters in a much greater detail than I can outline here in this clip or that is actually discussed in the textbook. For example, Article 7 of the VCLT establishes that those who represent the states who negotiate and eventually come to sign the agreement need to have full powers by competent domestic authorities, meaning the government. Before concluding an agreement, states of course have to negotiate its terms, which can take months, years, sometimes even longer than this. Think for example of international climate law and the Paris Agreement and the yearly COPs, Convention of Parties, in which states in meticulous detail and painfully hammer out word by word the specific paragraphs that are eventually then put to a vote. According to Article 9 of the VCLT, states may adopt the treaty either by consensus or by 2/3 majority, but it's really up to the states to decide what is the case here. Usually they opt for consensus. The act of consent will also differ from treaty to treaty, so the precise moment in which a state actually incurs an international legal obligation. In some more rare instances, this will be through simply signing the document, for example, at the end of the negotiations, at the end of an interstate conference. But more often, what's important is actually ratification. And ratification, of course, is the process by which, after signing the treaty, the parliament then gets to vote on and approve this international convention. A state may also accede to a treaty, once again, usually through a ratification process. An accession means simply that this state was not initially a part of the negotiations and the initial signing, but some years, sometimes even decades later, came in to sign, ratify this document, and thereby become a party to this treaty. One thing to remember for those instances in which there is a delay between the signing and the ratifying of a treaty is that a state actually does incur some more basic obligations called interim obligations that are applicable already in this in-between period. And these obligations are not the full list of operative paragraphs that we can find in the treaty, but rather a more general obligation to not defeat the object and purpose of the treaty. So not to undermine the very purpose of the thing that they have just signed and thereby given their preliminary agreement to. One final thing to remember and potentially check when you're confronted with a specific treaty is whether it says something about its entry into force. So the precise moment in time when it becomes operational. Sometimes it's simply a time delay, 1 year, 2 years, but more often, and this is applicable to multilateral treaties, there might be some provision that actually suggests how many states it will take before this treaty becomes operational. So, for example, a minimum of 20, 50, or 60 states. Again, it's up for the states to decide what this number is. But before this number of ratifications has actually been achieved, the treaty is not in force and the international legal obligations are not yet applicable to the state parties. This concludes the first video. In the next video, which is actually from International Human Rights course, I will discuss treaty reservations.